hearing in the appeal Radmacher against Granatino.
Yes, please.
My Lords, there are three types of prenuptial agreement, we would say, and if I adopt my learned friend's convention calling them prenups rather than either prenuptial agreements or prenuptial contracts, as that is.
It'll save us at least 5 minutes.
Indeed it will, my Lord. The three types of prenuptial agreement that there are first of all, those where no weight at all is attached to them. That would have been the historic position in this jurisdiction. It still is the position in a handful of jurisdictions in the world, such as Malta, which doesn't recognise divorce at all. The second type of prenuptial agreement is the one where it is advisory. It may well be extraordinarily advisory.
Did you say advisory?
Advisory, my lord, yes. Yes, indeed. It is not binding, and that, of course, is the third category of prenuptial agreement. Those jurisdictions which have decided largely by statute, but not exclusively by statute, as my learned lady Baroness Hale confirmed in the case of MacLeod. There are those jurisdictions in the United States, for example, where prenuptial agreements have become binding by virtue of evolution of the common law. The debate in this case, and my learned friend's advertisement of this case in his petition to the House of Lords as then was, signified that there was a dispute between us between whether or not prenuptial agreements should be treated as either Category 2 or Category 3. There is no such debate. Suitably chastened by the Court of Appeal, we have not proceeded with the argument that these should be presumptively dispositive. And therein lies the difference between those two types of expression. Presumptively dispositive means that, and I do apologise if your lordships already have this point, but it means that the contract would dispose of the whole of the dispute between the parties unless there was something which undermines the contract itself. So the contract on its face is binding absent those vitiating factors which would undermine a contract, say in the RBS and Ettridge situation.
So do you put that into your first category of a binding, or is it a fourth category?
It's the third category. It's simply presumptively dispositive is a Canadianism for what we would call a binding contract.
That's the position in Scotland, isn't it? The Scottish position is because the public policy rule doesn't apply there.
Right.
It's simply the force of the contract subject to the statutory qualification.
Absolutely. Indeed. So that's Category 3.
Yes.
Whereas in England, we haven't quite progressed to that stage. And as the Court of Appeal rightly said, and as the board said in MacLeod, that's going to be a matter for the Law Commission. It's going to be a matter for Parliament, ultimately. And we accept that. Although, valiantly, we tried to argue the contrary before their lordships in the Court of Appeal, their lordships were having none of it.
Sorry. So binding in this use of language means binding unless contractually defective.
Indeed.
And that in turn means presumptively dispositive.
Yes.
They're
indeed.
all interchangeable expressions, is that it?
Well,
Yes.
I'm not sure that that's correct, is it, Mr. Todd? There is a distinction to be drawn between whether something is enforceable as a contract, as I explained yesterday, and whether in ancillary relief proceedings, the court will regard it as presumptively dispositive of the court's decision in those ancillary relief proceedings. Those are two different things. So I think you're not arguing either of those things, are you?
Well, my lady, what I'm suggesting is that there's a second category of prenuptial agreement where the agreement itself is a factor to be taken into account within the ancillary relief.
Well, you're arguing for two now, aren't you?
Indeed, yes.
That's what you're arguing for.
Absolutely.
And so the only difference between you and Mr. Mostyn is precisely how much weight and in what circumstances.
Exactly, my lady.
Is that
Yes.
correct? Yes.
Quite. I'm afraid it's a rather less interesting point than if we had been arguing for the legislative change that we're accused of, or rather the Court of Appeal are accused of, because, of course, that didn't happen. And so we have the opportunity, though, within the Category 2 type prenuptial agreement of saying that these agreements can be afforded decisive weight in the right case. And that's where the real dispute between us lies, as to the weight that should be attributed to this particular agreement.
What's the difference between decisive weight in the right case and presumptively dispositive?
Presumptively dispositive, as we understood in the Canadian sense, is that there is a presumption that the contract of itself is going to dispose of the whole matter. If there were vitiating circumstances that undermined that contract, then in those circumstances, the contract itself would fall and the matter would be opened up. In a case where it is decisive, it is just one of many Section 25 factors. And so it falls to the court to determine whether or not it should be given decisive weight or a lesser weight or indeed no weight at all in the right case. That is very different to the situation that one sees in the cases that my learned friend referred to yesterday of, say, Simeone, where the contract was presumed to resolve the dispute between the parties. We don't say that is the case here.
Where you have a choice between two distinct alternatives, you can talk about something being decisive in the choice between the two.
Right.
This isn't that situation. And indeed, so far nobody's said that, have they, it's decisive to the extent that it's got to be applied absolutely rigidly.
No, and we don't say that either.
No.
We say that, and that there's a slight play on words in the way that the appellant presents their case, in how they say that it's presented being decisive. What is actually being said by the Court of Appeal is that the weight which we afford to this particular agreement is so strong, it is a matter of such magnetic importance, that it can be a factor of such overwhelming significance as to be decisive, i.e. to result in the decision being made along the lines of the prenuptial agreement.
So
and
does decisive mean the same thing as magnetic importance? I mean, you're really, these are interchangeable expressions, are they?
well, they're certainly dangerous expressions, and they're not expressions which are found within the statute itself.
Yeah.
We go back to the statute.
It only gets into the statute as all the circumstances.
Indeed. Indeed.
That's the only
yes.
way it gets in.
Yes.
It's not
Yes.
even specifically listed, is it?
It's not specifically listed, but then there are concepts such as fairness and sharing and so on, which are also not listed, but we would all accept that they are extraordinarily important. Compensation, for example, is another expression which doesn't find mention in Section 25, but we're all agreed it is of the most enormous significance in the determination of these cases. So
But that's the principle determining the outcome that you're attempting to achieve.
Yes.
Which is different from what you take into account on the way to achieving it.
Indeed, there is. I was simply addressing the point about the width of Section 25, and we say Section 25 is boundless. And in the right case, and this is our point about Crossley, we're not saying that this case is on all fours with Crossley. We're not saying it's fact perfect the same or even similar in terms of those particular facts. What we're saying is that Crossley establishes the principle, which is beyond argument, that in the right case, a prenuptial agreement can be given so much weight that it, in effect, decides the outcome of the case. And that's what we say rightly was applied in this case.
When you say it decides the outcome, you mean it is given full effect?
It is given full effect as part of all the circumstances. So a court would have looked at all the circumstances, age of the parties and so on, length of the marriage and all those other factors, and then deciding within all of those factors the existence of this prenuptial agreement fairly entered into would be given such weight as to be given effect within the discretionary exercise under Section 25.
So this case, and Crossley, on your submission, is in category 2. It's an advisory, but it is of such magnetic importance that you give it decisive weight, meaning you give it full effect. You don't discount it at all.
In the right case, absolutely.
And that's Crossley in this case,
Yeah,
on your
absolutely.
submission.
Yes, indeed.
Yeah, I mean, at the moment, I'm just trying to get the language that I can follow.
And in terms of looking at the language and the principles that perhaps might be applied to any agreement the parties enter into, and we look at this widely, one is perhaps assisted by the case of Edgar, which is in the authorities bundle 2, and it is worthy of revisiting, although revisited in our written case. And at tab 42, it's at page 893, and it's the often quoted dicta of Lord Justice Ormond.
33,
893, my lord, please.
no, the tab number.
Tab 42.
42.
And it begins, it's just below letter B, to decide what weight should be given in order to reach a just result to a prior agreement not to claim a lump sum. Regard must be had to the conduct of both parties leading up to the prior agreement and to their subsequent conduct in consequence of it. Just pausing there, we say that this was a fairly arrived at agreement, and as a consequence of that, the parties conducted their financial affairs on a separate property basis, right up until the time that, in fact, some time into the time, in 2005, that the husband said to the wife that he no longer had the necessary funds to continue with paying for himself whilst he was at university. Lord Justice Ormerod continues, "It is not necessary in this connection to think in formal legal terms, such as misrepresentation or estoppel. All the circumstances as they affect each of two human beings must be considered in the complex relationship of marriage." Again, my lords, we agree entirely with that statement, and that statement should apply to this prenup. So the circumstances surrounding the making of the agreement are relevant. And then Lord Justice Ormerod deals with the circumstances surrounding the making of the agreement. Undue pressure by one side, exploitation of a dominant position to secure an unreasonable advantage, inadequate knowledge, possibly bad legal advice, an important change of circumstances, unforeseen or overlooked at the time of making the agreement, are all relevant to the question of justice between the parties. And then, worthy of the greatest emphasis, we would say, is important too is the general proposition that formal agreements, properly and fairly arrived at with competent legal advice, should not be displaced unless there are good and substantial grounds for concluding that an injustice will be done by holding the parties to the terms of their agreement. There may well be other considerations which affect the justice of the case. The above list is not intended to be an exclusive catalogue. And then Lord Justice Ormerod quotes with favour the decision of Sir Gordon Wilmer in Right and Right, report of 1970, third volume, the All England Law Reports, page 209 at 214, that the existence of an agreement at least makes it necessary for the wife, if she is to justify an award of maintenance, to offer prima facie proof that there have been unforeseen circumstances in the true sense which make it impossible for her to work or otherwise maintain herself.
It is, Mr. Todd, I think it's
so
just in case some members of the court are not as familiar with this case as you are. We do have to read these words, recognising that what they were talking about was a deed of separation.
Indeed. Yes, indeed, my lady, yes.
So
yes.
This was a couple who had been married for quite a long time, had rather a lot of children, and had separated and had a properly negotiated deed of separation at that time.
Yes, indeed. Yes, indeed. I believe I was anxious just not to repeat what's already been said in our case.
Yes.
But, that's absolutely right. This is not a prenuptial agreement.
This is not a
case.
prenuptial agreement.
What we are saying is that these principles, though, should hold good for a prenuptial agreement in the same way as they would do for a post-separation agreement or even a post-nuptial agreement. And I'll come to that very shortly. Lord Justice Ormerod then continues, adapting that statement to the present case, it means that the wife here, who was the person who had entered into the agreement and was seeking to resile from it, it means that the wife here must offer prima facie evidence and material facts which show that justice requires that she should be relieved from the effects of her covenant in Clause 8 of the deed of separation and awarded further capital provision. Edgar, of course, as we describe it in our written case, is something of a fountainhead when it comes to those cases which deal with post-nuptial and post-separation agreements, historically post-separation agreements, but the principles which are embraced in here, we say, were embraced in the case of MacLeod, also for the post-nuptial agreement as well. So, if there is a fairly arrived at agreement, an attempt to compromise the parties' claims in the future, as well as it being the basis upon which the parties are going to, in all probability, on the continental model and on the facts of this case, model how they behaved during their marriage itself, then that, we say, means that this if properly applied to the prenuptial agreement, should devolve into essentially a two-stage test. The first of those stages is to ask whether or not there was something in the agreement at the time of its inception which vitiated it. And of course, that's an important point for anybody who wishes to attack either a prenuptial agreement or a postnuptial agreement, because in both cases, if there is some defect, which means the agreement itself is unfair, and we accept it is not necessary to think purely in terms of contractual terms such as misrepresentation, then in those circumstances, the agreement is a nullity. It's not something which attracts or should attract any weight. Because if someone's free will has been overborne by any of those factors, which, for example, Lord Justice Ormerod describes there, such as undue pressure, exploitation, duress, undue influence, and so on, then that is something which means the contract is completely bad. It is of no effect whatsoever. It's not, as Mrs. Justice Barron appeared to treat it, simply something which goes to the weighing exercise of the agreement. It's something which rules it out of play entirely.
In the law of contract, a contract is either binding or it's not. If it's binding, it applies without reservation. If it's not binding, it has no effect at all. And you have to have rules which govern whether it's one or the other. In a situation where you can have a halfway house like this one, there's not necessarily a need for such rules. You can have a more nuanced approach to what it was that would have made the agreement defective had it been a contract. You can have some situation where you say, well, if this had been known, of course, it completely vitiates any suggestion that there was agreement. Or, well, this might have been a material consideration. But no more than that.
Yes, that's right. But there are those vitiating factors which perhaps are not fairly described as innocent vitiating factors, where some party applies some pressure or they're guilty of duress, and there is an analogy with all of those. Any one of those non-innocent vitiating factors is going to render the agreement a nullity. If someone has achieved the agreement by some unfair pressure, I'm going to come on to the other factors, the more nuanced points in a moment. But we'd say in looking at whether or not the agreement itself is vitiated, a first port of call, a legitimate first port of call, is whether or not there are any of those contract-type vitiating circumstances which would suggest that someone has exploited their position in order to obtain an unconscionable or an unfair bargain. And in that scenario, which we say should be the first port of call, if that person were successful, the agreement is a nullity. There was not the meeting of the free minds. And in this particular case, that wasn't the position at all. The decision...
So you say, at this first stage, you've got to say either it's a nullity or you treat it as if every last T had been crossed and I dotted.
No, we say that at the very first stage, if the agreement is a nullity, it's of no weight. Of course. And it's not a factor at all.
Quite.
If, however, it is not a nullity, it becomes a circumstance of the case. It does not become something which must be enforced as of right.
No, it becomes a circumstance of the case.
Indeed.
But does it become then irrelevant entirely as to the extent to which disclosure was made, the extent to which advice was taken, etc., etc., etc.?
It depends how they are deployed. If they're deployed in support of an argument that, for example, in this case, the husband says, I entered into this agreement, and the absence of disclosure meant that I didn't properly enter into it with an informed knowledge, then what he is in effect saying is that he didn't give his free consent.
So it's a nullity.
Quite. Then
So
that would be a
are you
nullity.
saying he either makes good it's a nullity at the first stage or bust? In other words, or he can make nothing at all of the circumstances. Is that the submission?
Yes.
I'm just trying to clarify.
Yes, my lord.
But that
It
can't
is.
be, can it? To take pressure, pressure might be duress or it might be just pressure. Does that mean that if there is no duress, you can't take pressure into account at the second stage?
You can take into account the pressure, yes, indeed. That's, if you like, the second category of vitiating circumstances which I was going to come to. The first is those that would render any agreement contractually void, And then the second are those much wider circumstances which are unique to these sorts of agreements.
Well, wouldn't it be pointless to have a sort of preliminary issue or something as to whether there was pressure amounting to duress? And if there wasn't, then still take into account at the second stage?
Well, it depends how taken into account. But if you were saying that I entered into this agreement on the basis of pressure from the other side, and that renders, and that is correct, then that would render the agreement a complete nullity. If, however, you were saying that I simply came under some pressure, but I knew what I was doing and I was still happy to go along with this agreement, then in those circumstances, we would say that that then becomes a very important circumstance under Section 25.
And what about lack of information? The fact that there wasn't a complete disclosure wouldn't necessarily, in contractual terms, mean that the contract was a nullity.
Right.
But if one was asking oneself more generally whether it was fair or reasonable for the agreement to be given the weight you say should be attached to it, it might be a factor to take into account. Are you prepared to accept that it is relevant to ask the question whether or not there was complete disclosure?
It is relevant to ask whether or not there's complete disclosure, but again, it has to be on a fact-specific basis.
Yeah.
How is it that this husband, in this case, says disclosure affected his decision? One of the important questions which was put, I think, both in the Court of Appeal and again yesterday, and on both occasions not answered by Mr. Granatino, is how would he act differently if he'd had legal advice? How would he have acted differently if he'd had disclosure? And of course he didn't answer those questions because either way his case is sunk. Because he either says, well, had I had that necessary legal advice, then I would not have entered into this agreement, in which case there would have been no marriage, as was found by Mrs. Justice Barron. Or alternatively, he would have said, in respect of the disclosure, well, I needed that disclosure. Without that disclosure, I wasn't able to give an informed consent. And therefore, I didn't really give my consent to this agreement. And again, that would go to the question of whether or not this is a good agreement at all. So
you're not, if I can follow exactly what you're saying, each time you make a proposition, you're really saying that the question really is whether this is an agreement which should receive contractual effect. And but as I understood the position that was argued against you, and I would have thought was category 2 if it's
yes,
advisory.
Yes, indeed. I'm not saying you should get contractual effect in.
No, if it's advisory, then one may be able to take a broader view and say, well, yes, if one was looking at it in contractual terms, this would have to be regarded as binding, but there are other circumstances which make it unreasonable to hold the parties to their bargain.
There may well be other circumstances which are beyond a purely contractual vitiating circumstances. Yes. That makes it unreasonable for the party to be held to their agreement. Right. We accept that. And we accept also that the unique nature of these relationships, whether they be in a marital setting or a civil partnership setting, the particular pressures that can be brought to bear and so on, are of such infinite variety that it would be impossible to legislate for every single circumstance that there might be. And we certainly don't suggest that it is possible now to formulate a test for that at this stage. I think we made a reference to Laplace's demon, the creature that, because it knew everything that had happened in the past, was able to exactly predict the future. Such a demon is, of course, a creature of pure fiction. Likewise with these cases, the great strength of the Matrimonial Causes Act, what I described as the genius of it, was its flexibility, was its ability to look at each individual case and decide, should this agreement be regarded in the first instance as an agreement that the parties should be held to in any event? And one is going to be assisted in looking at whether or not this agreement is going to be something which the parties are going to have to be held to in any event by, in the first instance, looking at those easy scenarios where the agreement is going to be of no weight whatsoever. And they are those contractual ones. And in all those circumstances, the agreement doesn't get to go through to the next round. It doesn't get to be a factor in Section 25 at all. And it should attract no weight whatsoever in those circumstances.
Well, you run into a bit of difficulty with disclosure, don't you? Because, at least under English law, there are some contracts, the nature of which require disclosure, contracts of insurance. And non-disclosure vitiates the contract.
Right.
If we are looking at this abroad, there'd be a different approach. Non-disclosure would vitiate the contract if it was determinative.
My Lord, yes.
You're running the latter argument.
Well, my Lord, one of the difficulties which the Court of Appeal were faced with, and one of the reasons why they were unable to follow what Mrs. Justice Barron had said at first instance, is that one of the great lacunae, probably the greatest lacunae, in this case is notwithstanding that there was argument in affidavit, and indeed there was evidence as to this, as to the extent to which the husband would have known that the wife was from a wealthy background and that that would have informed his decision. It was a matter which was touched upon in evidence. My learned friend yesterday referred to the recently discovered transcript. The husband was asked whether or not he knew what his potential father-in-law did for a living, and he said that Katrine had mentioned that he had a company in Germany, but I did not know how successful until later in the marriage his companies were. He was asked about the nature of the company, and he said, you know, I think she might have said it was chemistry or company, but that is all I knew. Well, this is in the context of a man who had a chemist background.
Well, now we're getting into the facts, but
Quite.
as a matter of principle...
But there's no finding on this.
No, but as a matter of principle, I thought you were addressing this on
I'm so
principles
sorry,
to
Lord.
be applied.
Indeed, I'm so sorry, Lord. I
Particularly
rather ahead of myself there.
In the area of disclosure.
Yes, indeed.
Now, there are two possible contractual principles. One is, if there's non-disclosure of a material fact, the contract is a nullity. And the other is, if there was non-disclosure and had the fact been disclosed, it would have made a difference.
Yes.
The contract's a nullity.
And my Lord, the point of emphasis for that purpose, and in agreement with your Lordship's formulation, is this question of material disclosure. Take, for example, the lady who is considering marrying Mr. Bill Gates, were he to be free to marry again. She might say, well, I've got a pretty good idea that he is a supremely wealthy person. Would it be material in those circumstances if he gave no disclosure? Well, the chances are it would not be material at all. And what Mrs. Justice Barron didn't do on the facts of this case, and I appreciate I'm moving slightly off of principle, but I'll come back. What Mrs. Justice Barron didn't do in this case is make any finding as to the extent of the husband's knowledge. He said, well, the wife didn't give the disclosure, and of course, under the proper law of the contract, she didn't have to give any disclosure. But he didn't say what the state of the knowledge, she didn't say what the state of knowledge of the husband was when he entered into this agreement. So, in terms of principle, is disclosure one of those factors which would inform whether or not an agreement should be vitiated or the parties held to it? Then the answer is yes, it can be. It depends. It's again within the very broad spectrum which is presented by Section 25 of the Matrimony Causes Act.
Sorry, you used the word vitiate.
Vitiate.
Yes, but under Section 25, we're not talking about vitiating factors, are we?
No.
A vitiating factor, as I understand it, I thought by your definition, was one which undermined the contract's validity according to its proper law, and you've just said you didn't have to give any disclosure under the proper law.
Right.
So it can't be a vitiating factor. It might be, I think you accept, let me just clarify, it might be a relevant circumstance.
Indeed, I'm grateful.
Right,
to
well,
my Lord. It was
so
careless
I
use
think one needs to ask why it's a relevant circumstance, and then one needs, therefore, to look at the impact on the husband or the husband's interest in disclosure. Those are all other relevant circumstances.
absolutely. Quite, absolutely. Lord.
I'm sorry, so you do accept that even if it's not a vitiating, it doesn't render at the first stage the agreement a nullity, it can still be a relevant circumstance.
It can still be a relevant circumstance.
So you can discount it on that ground alone, that it's not quite as effective or not quite as decisive an agreement as others might be. I mean, is that, I'm just clarifying, I'm
yes,
not...
that's not the case here.
I see,
But
it could be.
But it could be because, as we accept, rather like in all those 19th century cases on fraud, that there is an infinity of variables in respect of one of these cases. There might be, there was not in this case, there might, for example, be some innocent mistake which has taken place, which does not render the agreement a nullity, but it might put a degree of colour on it, which means that it wouldn't have the effect it would have otherwise.
That must be right. If you're in category 2,
Indeed.
then it's advisory.
Indeed.
And the question really is to what extent is it advisory? I mean,
Absolutely.
that must be a question of circumstances and a question of degree.
And one of the critical facts for determining that is potentially the question of disclosure. And what we don't have in this particular case is Mrs. Justice Barron saying what the husband's state of knowledge was. We know that he knew that his father-in-law owned a business which was involved in chemistry, and the husband says, well, I don't know anything more about it other than that. Well, we challenged him as to that, saying, well, that's unlikely in circumstances where not only are you an investment banker, but you're a chemist. And subsequently in the marriage, only 3 years later, he was talking about going off to work in exactly that business. The idea that he would have known nothing at all about it, we suggest, is fanciful, but we don't suggest that from the position of any finding of Mrs. Justice Barron, because she made no finding either way. My learned friend yesterday presented this as being somehow a point in the husband's favour, because he said no finding had been made that the husband did know about this, but likewise no finding was made that he did not know. And yet this was rehearsed in the affidavits, it was the subject of oral evidence between the parties, and it was not the subject of a finding. Instead, what we had from Mrs. Justice Barron was a finding that that first group of factors, which would have been the knockout blow, which would have rendered this agreement of no effect whatsoever, she found that those were not present in this case. And if I might invite your...
Just before we get into
so
the facts, I just want
We'll
to
get back
be
to
quite clear as to your submissions of principle.
Indeed.
Your submission of principle is, if there is a factor which would have rendered the contract a nullity, if it were treated as a contract, then the English court should disregard the prenuptial. Is that right?
It is. Yes,
And do you answer that question having regard to the proper law of the contract or the English law of contract?
My Lord, we say that in terms of the formation of the contract, you should have regard to the proper law of the contract, if only for this subjective reason, and that is, it informed how the parties themselves went about achieving their agreement. It's not a case of being concerned about the formalities, such as agreements under seal or anything such as that. It's a case of the hoops which they thought they would have to jump through in order for this agreement to be binding. Because the impression that one is left with in this case is that this husband was going to sign this prenuptial agreement. He knowingly entered into it. He was going to sign it come what may.
Can we keep the principles separate from the
Certainly,
facts
Lady.
of this case? Because I'm trying to understand your principles.
Yes, well, let me come back to
If
principle.
you say, you say, if it is a nullity as a contract, well, then it has to be disregarded.
Indeed, my lady,
You
yes.
have to go on to say, according to its proper law, because it is a nullity as a contract under English law anyway. And so you would fail at first base unless you went on to say it's governed by the proper law of the contract or some other principle.
My lady, we say that as a contract, it would be valid under its proper law. In terms of how prenuptial agreements should be looked at more generally, i.e. not in just this case, but the more general principle, we say that all the circumstances of the case pertaining to the agreement at that time should apply, and by analogy to contract law, but not applying the exact dicta of contract law, so we're embracing what Lord Justice Ormerod said in the case of Edgar, those sorts of factors would render an agreement a nullity.
But they wouldn't render it a nullity. I mean, we're getting
Because
we're getting
parties didn't
so
consent.
confused. It's a nullity already because English law doesn't regard it.
As regards to contract.
Forget the foreign element in this case. It's a nullity already. It may be a relevant circumstance. Nobody has argued that because it was a nullity, because it was contrary to public policy, it should be disregarded altogether. Mr. Mostyn has not argued that. That has not been argued for a long time, interestingly, but nevertheless. So we move on. It's not something to be regarded as irrelevant. But we're not looking at it in purely contractual terms.
No.
So I suppose we're saying, were it to have been capable of being a valid contract, would it have been completely nullified by something that would make it invalid? Or is there something else in the much broader Edgar terms which means that it shouldn't be given much weight? Is that what you're saying?
Indeed. And, my lady, what we're saying about those factors which are set out, mistake, undue influence and so on, is that they are helpful pointers to say that the parties didn't really enter into an agreement because their free will was in some way suborned. And in those circumstances, you don't have an agreement. So if someone procures a prenuptial agreement through duress, there is no agreement. It's of no weight whatsoever. And that's where all of those particular factors come into account. The factors.
Imagine under German law, duress isn't an answer to a claim in contract. What then?
If that was the German position.
Yes.
And so although the agreement was obtained by duress, well, one would have thought that we would fall within that extraordinarily narrow category of public policy where we don't recognise the law of foreign contract.
Well, I'm bound to say I find your proposition that you consider whether the contract is binding by its proper law at stage one, a surprising one, because we're talking about the exercise of an English jurisdiction and what weight the English jurisdiction gives to a factual situation where the parties have agreed in certain circumstances. And the answer should depend upon whether the contract was governed by New Zealand law or German law. That strikes me as, I must say, surprising, because we are outside strict contract.
My lord, yes, it's my fault for not being clearer. What we're saying that the proper law is useful for determining is whether or not these parties entered into this agreement freely. So that has a bearing...
Freely?
Freely.
Well, you don't need law to tell you that, do you?
Well, the law imparts certain circumstances which say that the parties may have had their free will suborned by there being an absence of...
Well, free will, again, is a concept one can understand, and the relevance of whether it was freely entered into or not is something I can understand.
Right.
But the fact that there wasn't disclosure of something which, in the particular circumstances, was wholly irrelevant.
It's a question of whether or not, as part of the freely concept, is a question of whether or not someone has made an informed decision to enter into the agreement.
And so if German law says, well, non-disclosure vitiates the agreement,
Would
that have made all the difference in this case?
If German law had said that the agreement was vitiated, then that would be the end of it. There would be no agreement. And
that's because the agreement only has relevance in the context it's made. Parties
Indeed.
make agreements in a particular legal context, and they expect that context to govern their agreement. They may be told that if they go somewhere else, the law of the forum will override it. But can I just ask, is your proposition right that if under German law it was unenforceable, it would necessarily be entirely irrelevant to a divorce in English law? Because let us suppose, just to take an example, that it was unenforceable. I'd prefer the word unenforceable to null, actually, because it seems to me at the moment to reflect more precisely what the position is but in English law. But let's suppose it's unenforceable because of a minor misrepresentation. And the minor misrepresentation, it can be shown, would have meant that that particular agreement wouldn't have been entered into. There would have been a slightly adjusted provision for maintenance. There would have been maybe £1,000 more a year. You'd still, I would have thought, say, look, we can see that this agreement is a pretty good guide to the way the parties were thinking. It may not be enforceable itself, but it's still a circumstance. They were prepared to agree that, and they thought that was fair, and they've conducted their lives on that basis. And whilst we can't enforce it, nonetheless, it's a relevant circumstance.
Yes, that's correct. That must be right.
Yes.
And so the circumstances which I was referring to were the more extreme circumstances where, in effect,
if someone's will is overborne, if there is real duress.
Indeed.
Certainly.
Yeah, the extraordinarily strong cases, they are the ones which are the ones which would render any agreement or any contract a nullity. But then there's a second consideration to take into account, which is part of all the general circumstances of the case. And that would, for example, look at whether...
Sorry, if we're trying to get really clear about the principles and just sticking with English proper law now, forgetting about everything else.
Indeed.
Nullity, it's actually quite a strong thing to say that parties who think they made a contract is a nullity. An awful lot of the situations you've been positing would actually give rise to the equitable remedy of rescission, wouldn't they? I'm sorry to go into these technicalities, but that is a discretionary remedy which would depend on whether you move quickly to seek it,
yes,
whether the parties can be put back in the same position as before. So I don't think nullity is the best word to describe.
No, it may well...
Unenforceable, or vitiated may be better words.
Yes, yes, indeed. They may well be better words. I don't demur for what your lordship says. The point which we emphasise, though, it's the circumstances at the time of the making of the agreement are all important, and they have to be looked at, both in terms of seeing whether or not this agreement can be regarded as having no effect whatsoever because it was procured in an unconscionable way, or in the second scenario, that the agreement should still be taken into account even though it might be imperfect. And both of those require a consideration of all the circumstances at that time. And they do not require, and we join issue with Mrs. Justice Barron in respect of this, they do not require a simple checklist which requires so many ticks next to boxes. It requires a true looking at the circumstances of the parties at the time. And then in the right case, we say, within the discretion that the court has, the court can say that that agreement is something which should be given so much weight that when set against all the other factors under Section 25, it is that factor which is the decisive factor. And in that context, I can deal very briefly with something that we spent a lot of time on yesterday.
I'm sorry to interrupt, and forgive me for going back to the question of disclosure, but do I understand you to submit that because no finding was made by Mrs. Justice Barron as to the extent of the appellant's knowledge, that the question of disclosure is no longer relevant?
The question of disclosure is always relevant, and that's why we complain that Mrs. Justice Barron failed to answer a point that was before her, which is the extent to which, notwithstanding whatever disclosure might have been given, he had actually had knowledge, and secondly, the extent to which he had opportunity to pursue that disclosure.
Well, we're in the position that she hasn't made a finding, you say. Now, how then do we deal with the question of disclosure? Because it seems to me that if you were in a position to say that there had been full disclosure here, that would surely support the suggestion that the agreement should be given decisive effect. Is that all right?
Indeed, and what we say is...
I'm sorry to interrupt again, but in the absence then of full disclosure, does that not derogate from the proposition that the agreement should be given decisive effect?
The answer is it can be. Again, it needs to be looked at within all the circumstances of this case. And the important factor here is that, like Mrs. Edgar, there was the opportunity of disclosure, and in this particular case, this disclosure was not pursued. That this husband did not investigate, even though he was aware of the fact, he did not investigate the disclosure which was potentially available to him. And that's something which is recited on the face of the agreement itself.
Mr. Todd, I've been trying to reformulate your stage one. It's not entirely, I think, as you advanced it. But is this really what you're saying? Stage one is, you ask the question, were the circumstances in which the agreement was concluded such that it would be unconscionable to give any weight to it?
Yes.
Is that what it boils down to?
That's what the first part of it would be, indeed.
Unconscionable to give any weight to it, was it?
Yes.
Yes.
Yeah. Yes, well, that I can follow as a proposition.
Yes, indeed. Yes. And in looking at the circumstances, we say nothing is ruled in and nothing is ruled out, because what the court has to determine is, in effect, the state of mind of the parties at that time. And that's why it is an important question, and we don't understand this to be properly described as counterfactual. It is an important consideration as to how the husband would have acted in any event had he had those other matters available to him. And of course, it has to be recalled that both the question of opportunity of disclosure was expressly raised. It was, in fact, even recited in the agreement itself. And likewise, in respect of independent legal advice, it's our primary contention there was independent legal advice as understood in civil law jurisdictions. But quite apart from that, there was again, as the Court of Appeal rightly found, the opportunity of there being legal advice. This point about the extent to which these things may be given weight is we don't understand how it can be seriously contested that in the right case these matters can be decisive. And when we say there is an analogy with Crossley, and it's in our written case, it's not in terms of it being fact-specific. We deal with this in the Bound Volume 1 at page 47.
Paragraph number?
It's paragraph number 6.12.8. And, my Lords, may I apologise for the two additions, the second one being with the typos corrected. That's the only difference. There's no substantive difference. In paragraph 6.12.8, we say exactly this. We say, having adopted the correct test, he adopted a Crossley-based weighting of the agreement. This is in the context of Lord Justice Wilson's decision in the Court of Appeal. And then we go on to say, parenthetically, of course, the facts of Crossley and this case were different. One difference is that this agreement had a proper law provision which made it binding in the parties' home countries, as opposed to the Crossley agreement, which of course they entered into in this country and therefore could never be binding in the same way as this agreement could be. We then go on to say he then directed a solution which was practically identical to the other agreement's case, MacLeod. So at no stage are we saying this is fact perfect the same. We're simply saying that it was open to the Court of Appeal in the wide exercise of discretion which is permitted under Section 25 to come up with a Crossley-type resolution, i.e. attach decisive weight. Of course there are differences between this case and that case, and we've never sought to argue otherwise. The stages that we say is, having looked at the agreement at its time and decided whether or not that agreement itself was vitiated, and having formed a view as to what the agreement is, then requires a second and later consideration, which is whether or not the agreement has subsequently become manifestly unjust. And that, again, requires a consideration of all the circumstances of the case at that time.
So it doesn't have to have become manifestly unjust by the second stage before you cease to give it full effect?
If one had a wholly accepted prenuptial agreement, which was not the subject of any real criticism at all, let's say in this case, for example, the husband hadn't made all those criticisms about not being able to understand the language and so on. He said, yes, I accept this, I accept it's binding and so on. Then we would say that absent there being any other changes that made it manifestly unjust, then it would fall to be determined in the same way that Crossley fell to be determined, which is it would be given decisive weight.
I'm not clear just at what stage the manifestly unjust test that you just mentioned comes into play. I understood the first stage is really looking at the date when the agreement was entered into. Yes. And one may have flaws in the way that all took place, which would make it unconscionable for the agreement to receive any effect at all. Now, you're accepting, are you, that one can step back from that initial stage and nevertheless look at the way the relationship developed and so on to decide whether it would be manifestly unjust to hold them to the terms of the agreement?
Indeed, yes. Yes, indeed. I mean, if one takes the situation where, for example, a husband and wife enter into a prenuptial agreement and then 9 or 10 years later, completely unexpectedly, the wife is struck down by some debilitating illness which leaves her in a wheelchair, then the chances are that it will be manifestly unjust in those circumstances to hold her to, for example, a separate property regime prenuptial agreement. And in those circumstances, the court would have to adopt a different approach. And that's not unique to this jurisdiction. Of course, the Germans also, within their provision, include provision for those circumstances of real need. Other examples, perhaps more common examples of where something might become manifestly unjust or requiring some variation are, for example, the situation in MacLeod and in this case where there needs to be provision for children, there having been no children at the time of the prenuptial agreement. And that's a discrete matter which can be dealt with discreetly. We don't accept the description of that as being Schedule 1 relief. There are, of course, huge analogies between Schedule 1, which is the financial provision which is made where the parties have not been married at all. But that's all. There are analogies. One tends to see the same quantums of maintenance for children because children...
No, with respect, Schedule 1 applies to all children.
Yes, I'm so sorry. I was coming on to the point about it being described as Schedule 1 as if...
Normally, of course, it only needs to be applied where the parents are not married to one another.
Indeed.
Because normally if they're married to one another, there are divorce or other proceedings under which the same orders can be made.
Right.
But it applies to all children.
It does, maybe. No, I was referring to it in the context that it was used by the appellant, which was to say that this husband had in effect lost all of his rights, save for those of an unmarried father. And of course, Schedule 1 does apply more widely. But in an unmarried father situation, one would suggest almost never, although there is jurisdiction for it, one would almost never see, for example, the capitalisation of a carer's allowance, which is what happened in this case. So there are differences, but they're all born of that real change which took place, which was recognised as being a legitimate point of departure from the prenuptial agreement in this case, and indeed in the case of MacLeod. But in looking at all of those factors under Section 25, it would be fair, we say, to adopt a similar approach to what the board has adopted in the case of MacLeod, because the difference between the prenuptial agreement and the postnuptial agreement is essentially twofold. The first one is that the amount of pressure that can be brought to bear on a prenuptial agreement is different to on a postnuptial agreement. But that's something which we say goes to the quality of the agreement. And then the second point is the relief is under Section 23 and 24 for varying that agreement rather than Section 25. So, to recap in respect to those 2 points of principle that we say, the first is that in this jurisdiction, prenuptial agreements are a factor to be taken into account under the Matrimony and Causes Act. The public policy exception extends only insofar as saying they are not to be binding, they're not to be given contractual effect. They don't therefore fit into that third category. And the second point we say is that in looking at the weight that should be given to the agreement, one can look at two levels. First of all, at the time of the formation of the agreement, and in some circumstances that will result in the agreement being given no weight whatsoever. And then in the second scenario, at the time of the ancillary relief hearing, to see whether or not it would be manifestly unjust to hold the parties to their agreement.
Where do you get this manifestly unjust?
Manifestly unjust is a phrase that we borrow from MacLeod, and if I might just...
MacLeod is in volume 4 at 60.
Indeed, I'll go from there. Lady, I'll go from there, friend. Paragraph 41. When the board is dealing with the question of the weight to be given to an agreement, and the board says this: the question remains of the weight to be given to such an agreement if an application is made to the court for ancillary relief. In Edgar, the solution might have been more obvious if mention had been made of the statutory provision relating to the validity and variation of maintenance agreements. One would expect these to be the starting point, and we say the same should hold good for prenuptial agreements. Parliament had laid down the circumstances which a valid and binding agreement relating to arrange for the couple's property and finances, not only while the marriage still existed, but after it had been dissolved or annulled, could be varied by the court. And, my lords, just pausing there for a moment, we say that if a prenuptial agreement is not given contractual effect, if it's not held to be binding, then it is something which is capable of variation or change, not under these sections, but under the earlier sections of sections 23 and 24, which are the provisions which the exercise of discretion is informed by section 25 for. And then it goes on to say, at the same time, Parliament had preserved the parties' rights to go to court for an order containing financial arrangements. It would be odd if Parliament had intended the approach to such agreements in an ancillary relief claim to be different from and less generous than the approach to a variation application. The same principle should be the starting point in both. In other words, the court is looking for a change in the circumstances in the light of which the financial arrangements were made, the sort of change which would make those arrangements manifestly unjust, or for a failure to make proper provision for any child or family. And I'm afraid I've telescoped those two into being the single concept of manifestly unjust, because a failure to make proper provision for a child or family would be manifestly unjust. On top of that, of course, even if there is no change of circumstance, it is contrary to public policy to cast onto the public purse an obligation which ought properly to be shouldered within the family. And, my lords, what we say is that this principle, which the board said should hold good for postnuptial agreements, should hold good for prenuptial agreements, not least because if one gets the reductio ad absurdum example of someone entering into a postnuptial agreement, that's something that can be done at the wedding reception, whereas the prenuptial agreement might have been done first thing in the morning. It could be a matter of hours difference in terms of the execution of the agreements. One would always need to look at those on what we say is a fact-specific basis. But in terms of the principles to be applied, there is no good reason, once one has accepted that prenuptial agreements do not have contractual force and therefore are variable under sections 23 and 24, there's no good reason to depart from the principle which is set out in paragraph 41 for MacLeod for what we describe as the very analogous postnuptial agreement. Of course, the critical difference between the postnuptial agreement there and the post-separation agreement in the Edgar case is that the postnuptial agreement, as we say, can be made at any time after the signing of the register. And what has been happening, and my learned friend said he had no experience of this yesterday, well, I have experience of 6 cases where this has happened, is that people, instead of entering into prenuptial agreements, are either entering into a hybrid where there's a prenuptial agreement and then a postnuptial agreement in similar terms immediately afterwards, notwithstanding the case of Brodie, or alternatively simply entering into a postnuptial agreement. The postnuptial agreement being signed a couple of days after the wedding, rather than at least 4 weeks or so before the wedding, in order to get round that potential difficulty. Well, that is an absurd situation, if that is how the matter is to be interpreted.
So that's what's going on, is it?
Indeed.
How do we know that? Where do we see that?
Well, there's nothing other than anecdotal. My learned friend yesterday said he knew no cases of that. I know of 6 cases where that has happened, where people have said, well, we'll enter into postnup immediately afterwards, and thereby take advantage of the MacLeod situation. I think, in fact, there was an article in last Thursday's Times where a solicitor involved in similar cases said more or less the same thing. It's a case of, if there is a perception that postnuptial agreements are favoured so much more than prenuptial agreements, that the principles are completely different, that they are watered down as much as this husband would have them watered down, then just wait a few weeks and have them signed later. And in both cases, and one of the reasons why these are not like contracts is the consideration, and I use that in inverted commas, is the marriage itself. And so in a prenuptial agreement, if someone says, well, I won't sign it, ultimately the remedy is, well, then don't get married. And the marriage doesn't take place. In the postnup, which happens immediately afterwards, as we said in our written case, the remedy is the same. The remedy is, well, then the marriage will not have existed. We'll simply look at the marriage ending if you won't sign the postnuptial agreement at this stage. it's a purely theoretical situation which never happens in either scenario.
There's all the difference in the world between saying, I won't go down the aisle with you unless you sign this, and saying, even at the wedding reception, well, now we're man and wife, I'd like you to sign this.
Yes.
There's all the difference in the world.
Well, the reality is in the vast majority of the cases, both of them are going to get signed because there isn't that sort of animus. But if one took the extreme examples suggested as being illustrative of how these matters can be looked at differently, the only difference is that in the second example of the postnuptial agreement, the relief that is available is an ancillary relief claim born of a marriage lasting a matter of days, potentially. So it's not a question, we say, that would go to the question of principle. It's a question that would go to how much weight that particular agreement, be it a prenuptial agreement or a postnuptial agreement, should attract in those particular circumstances. There are, for example, the Crossley prenuptial agreement, which is extraordinarily strong. One might think of plenty of examples of postnuptial agreements, and we've referred to some in our written case, of where people enter into postnuptial agreements under real pressure, or that the circumstances surrounding those agreements are such as to call them into question.
Well, presumably all the examples you've given of people who enter into postnuptial agreements immediately after the marriage are cases where, before the marriage, one party said to the other, and they've agreed, that there must be a postnuptial agreement. Right. And the idea that someone then keen to get married reneges days after is a little fanciful. So, absolutely. I mean, if there's pressure in one, there's pressure in the other.
Right. And we say they should be treated the same, because invariably what happens, in all the 6 cases I can think of, what happens is parties go to solicitors and say, we would like a prenuptial agreement. We then have to say to them, well, the current position in respect to prenuptial agreements is not terribly clear. The position in respect of postnuptial agreements, thanks to the board in MacLeod, is very clear. And therefore, you're better off having, and there's a bit of a difference of opinion between different firms of solicitors in this. Some say you should have a prenuptial agreement and a postnuptial agreement, notwithstanding the 1917 case of Brodie, which seemed to suggest that would be problematic. Or others who say, well, because of the 1917 case of Brodie, you should just have a postnuptial agreement. But in both cases, they're agreed before the marriage. It's quite clear to the parties to the marriage that that's what they're going to be doing. And I know of no example where they've not then been signed, because it's departing into the realms of the most theoretical jurisprudence to talk in terms of a difference between these two sets of relationship. But it has, in terms of practice, led to real difficulties for the profession in terms of advising people how to deal with these matters. And the safest course to be adopted is to say, by all means, agree your terms, but do it as a postnuptial agreement, because we know you'll be within the case of MacLeod.
But why is that a difficulty?
It's not a difficulty.
It's perfectly clear and simple.
It's not a difficulty insofar as it leaves a great deal of uncertainty between parties who say, well, I would rather know that this is what we are going to agree before we enter into the marriage, so that scintilla of a possibility that one party might say, well, actually, I've decided post-honeymoon I don't actually like you, I'm not going to sign your postnuptial agreement, that doesn't happen, so that people have that great degree of certainty. But we're talking about the principle of it, and we say on principle, there's no good reason for these two to be treated differently at all. And in that regard, the Court of Appeal also struggled a bit to see with how it is that a prenuptial agreement should be treated so very differently to a postnuptial agreement. It's not also, at the moment, it's simply a case of uncertainty in any event, because there is no decision which says that what is said in paragraph 41 of MacLeod does not apply to prenuptial agreements. The court still, as it must do, retain the discretion under the Matrimonial Causes Act to do what it regards as fair, and that is not undermined either by paragraph 41 or indeed by 41 being extended to prenuptial agreements. The burden, though, if that's how it's described as saying, looking at the change of circumstances, is a fair one. And what underlines this case in terms of its factual matrix, is that this is a husband who has made two decisions entirely of his own free will, and he does not wish to accept the consequences of those two decisions. The first of those decisions was he chose to enter into this prenuptial agreement, and it was found that he entered into this knowingly and willingly, but I'll come to that in a moment. That was, of course, of real advantage to him, that prenuptial agreement, because it protected him in respect of his future earnings. It was not, of course, the case at the time of that prenuptial agreement that this wife was worth £100 million. She wasn't worth anything like £100 million. She was worth something over £1 million Deutschmarks, and she had some shares, and that was pretty much it.
Some shares. Some shares.
She had some shares, yes. And the shares were to increase because of this agreement. Because of this agreement, this was a shareholding which was to increase, but most importantly, her cash holdings were to increase. Also, of course, the 100 million figure is not the figure which Mrs. Justice Barron came to in any event. She came to a figure of in the low 50s of millions. Pounds, indeed. The secondary part, it was argued that because of her dividend income, one could ascribe a value to the rest of her shareholding. Well, her dividend income post-decision of Mr. Justice Barron has been zero, and so therefore one might from that extrapolate a value of zero. Doubly so because one of the features of this case is that if the wife was not married in a separate property regime, then she would potentially lose her shareholding for just its nominal value, and that was the subject of expert evidence for Mrs. Justice Barron. So she would lose that shareholding at all. And it is the case that there are ongoing proceedings in Germany where my lay client's sister is suing my lay client as per that term, as was contemplated and as was in expert evidence before Mrs. Justice Barron. So she does stand a real risk that if it turns out she was not in a separate property regime, or if this agreement was not to be given effect, then she loses her shareholding. So it was never £100 million a case at the time they entered into agreement, and it certainly isn't later. But
do we have somewhere in the papers the agreement under which if she wasn't married in a separate property regime, she would lose the shares as a matter of interest?
My Lord, yes, it's contained within the report of Dr. Kirchner, Professor Kirchner, I'm so sorry, doing him a service. It's in Appendix 4, my Lord, on page 125. Appendix 4, 125.
And what about the information about the ongoing proceedings? Are they in the papers?
There's no detail of those proceedings. That's something which I'm...
Sorry, I'm hot. Are you saying that if this court were to restore Mrs. Justice Barron's judgment, your client loses not only the additional amount that divides hers from the Court of Appeal, but some further sum as a result of some consequence in Germany of losing this litigation?
Indeed, my Lord, yes. And it's...
Where's that?
Appendix 4, page 125.
Who's finding? I mean, where is all this dealt with in the judgments or in your skeleton argument?
It's dealt with in the judgment of Mrs. Justice Barron, where she expresses the hope that it won't be a problem because as far as she is concerned, the decision does not touch... so sorry, I've mislaid my... Perhaps the starting point should be page 125 in Annex 4, or Appendix 4, which deals... Appendix 4, please, my Lord, which is where we have the professional opinion of Professor Kirchner. And then, if perhaps we could have open at the same time, page 91 of Annex or Appendix 1, which is also described as bound volume 2, page 91.
That's the judgment, is it?
Which is in the judgment of Mr. Justice Barron, yes, indeed. And as the learned judge summarises what's said at page 125, in her paragraph 77, there's that helpful comment there, where he says, at 77A3, Professor Kirshner confirms there is a risk pursuant to Article 15, Para 3 of the Articles of Association of Macquarie Nagel, the company run by Carolyn, who is the elder sister, that if the English court decides that the prenuptial agreement is invalid, the wife could well forfeit her shares. Specifically, the letter states, inter alia, if the British court makes an order providing for a financial settlement which includes the partnership interest in the company, despite the existence of a prenuptial agreement, which provides for the separation of goods pursuant to Article 15, Para 3 of the Articles of Association, and it says, Article 15, Para 3 of the Articles of Association satisfies this requirement. It is precisely worded and clearly expressed the company's intention to ensure it's not affected the family relationship of its shareholders. The objective of the exclusion clause is to prevent the company being exposed to risks arising from the financial settlement following divorce. In any event, a British court will have to assume if it makes a financial provision order which extends to the partnership interest, thereby failing to observe the choice of law clause in section 3 of the prenuptial agreement, that it will, as a result, be possible to exclude Catherine Radmacher from the company.
I'm not quite sure what he's contemplating there. I mean, there are various ways in which you can take account of it. It may be just taking account of the overall resources, which would result in some kind of payment which wouldn't actually touch the interest as such.
Yes.
The other would be some kind of assignment of an interest or a partial share in the interest. Which is he, what is he thinking of?
Well, Lord, that's why I was going to contrast this with what Mrs. Justice Barron says in her summary of what Professor Kirshner says,
yes,
as opposed to what he says in the appendix,
right,
where he's rather fuller than the judge made a finding in paragraph 80.
Yes.
You get a chance to speak at the end. Because
so he's saying, in fact, yes, I see the point that paragraph 80 is saying that the wife's shareholding as such is never under a threat of a transfer. So that's the point I'm really making, and I can understand the point that if you dilute the interest by possibly contrary to the articles, if there are such things, you might damage the wife's interest in the company, but that doesn't seem to be what's being contemplated here.
No, that's exactly how Mrs. Justice Barron deals with this concern. And certainly the proceedings by Carolyn are being resisted by the wife in Germany, but certainly Carolyn seems to be of the view that the Article 15, paragraph 3 is engaged, and she is pursuing that litigation in Germany. Of course, neither I nor, for that matter, Mrs. Justice Barron are experts on German law. We don't know how it is that they are going to interpret what is said within that particular article, or indeed how German company law is nuanced, so that the threat to a shareholding is the same as if there was an actual application against it, as opposed to there being a threat to the shareholding by there simply being the person outside of the marital property regime. And that's where Professor Kirshner's observations are important in just this one paragraph, page 125.
Well, in what respect does a lump sum order for the payment of money constitute a threat to the shareholding?
Well, that's probably explained in this paragraph, my lady, where he says, pursuant to Article 15, paragraph 3 of the Articles of Association, a resolution can be passed excluding a married shareholder who for a period of more than 3 months has not been living under the marital property regime of separation of goods.
Sorry, where are you reading?
I'm so sorry, Lord, it's page 125.
Has that resolution been passed?
Of Article 4.
As far as we're aware, it has. It certainly has been the subject of
But he is living under a
Actually,
he is living under a separate property regime. That's the whole point.
If it has been passed, then the bird has flown regardless of the result of this.
Quite. I'm so sorry, Lord. That was the wrong answer. I was thinking that your Lordship was thinking of something else. This resolution, the one pursuant to Article 15, paragraph 3, that resolution has not been passed as yet. No. That said, of course, it is the case that the sister is a majority shareholder anyway.
So what are the proceedings she's bringing if she hasn't passed the resolution yet?
Yes. What has happened is that Carolyn has decided, and this was referenced there being no dividends, that there should be no dividends at all paid to the wife because of the operation of this. So the legal proceedings centre on whether or not dividends should be paid or not. Yes. Where's that reference? 177.
I'm absolutely lost. I mean, even under the judge's order, why isn't the same threat there?
Well, Lord, the position in respect to this is dealt with in the wife's affidavit of April 2009, and that's found slightly later in the same bundle as where we have Professor Kirshner's opinion. It's at page 177.
I'm very unhappy about going into this factual background, insofar as it's not reflected by
Certainly
any judgment. It does seem to me that, standing back, it would have been very material if the position had been that the wife would be stripped of most of her assets.
Indeed.
If this agreement were not given effect.
Well, she certainly would be stripped of a good part of it, yes. It is still a matter of controversy, though, within Germany. And I mentioned it just at this stage because it has a bearing on the extent to which third parties are affected by this prenuptial agreement, by this decision of this husband to enter into this agreement.
I mean, with the greatest respect to Professor Dr. Kirshner, he doesn't make very clear how a provision in articles which is clearly directed to ensuring that the company is owned only by a limited number of family members is infringed by a payment of an order for the payment of money. If the judge had said, Mr. Granatino shall have a share in this particular asset, namely the 16% shareholding, that would be different. But that's the last thing that either the judge or the Court of Appeal said. And so how can it fall within Professor Kirshner's concern on page 130 that a British court will have to assume if it makes a financial provision order which extends to the partnership interest? It didn't make an order extending to the partnership interest. It was an order for money which had nothing to do with the partnership.
And that was the finding of Mrs. Justice Barron.
Yeah, well, on the face of it, that's the end of it, isn't it?
Well, except it's not the end of it because there's been litigation in Germany, which is...
That may be misfounded. I mean, haven't we got to judge the position as we see it?
We do. The point that I was making, and this describes it, is these prenuptial agreements, and certainly this prenuptial agreement, don't take place in a vacuum. It's often the case that there are third-party implications in respect to them, and they include directly upon the wife. The better illustration, of course, is the father who advances money to his daughter, safe in the knowledge that there is a prenuptial agreement.
Well, that is this case, you say, isn't it?
It is.
Yes.
Indeed.
Can I just ask, I mean, you may come to it at some point, it's a question which has interested me. Is there any suggestion, and is it dealt with in the judgments, that there's relevance attaching to the fact that the husband, during the marriage, decided to leave banking and thereby, in fact, considerably reduced his income? I think you told us a moment ago that, in fact, he continued to operate on an independent financial basis until 2005. So maybe the previous decision, which was, 2003 or something?
He left banking in 2003, yes. But carried on keeping the separate property regime effectively going.
So nobody has attached any significance to that decision. It's not being said that he did it in reliance on financial support from his wife or anything like that.
Well, the decision in respect to that by Mrs. Justice Barron is dealt with in her paragraph 139. So if we could perhaps go in Appendix 1 to... to page 111, my lord.
Yeah. Where does Mrs. Justice Barron discount the risk of what Professor Kirkman was suggesting?
That was at page 77, I think, my lord.
Is it paragraph 80?
Paragraph 80.
Mr. Austin directed our attention to.
I'm so sorry, 92.
Yes, page 92.
91 to 92.
Yeah.
I was just coming over to that.
And she does make the point, and I think this is certainly what I would understand, that the real risk, I would have thought, to the shareholding is the transfer, because ultimately what one is concerned about is the rights that are attached to the shares.
Yes.
And there'll be a voting power and one thing and another, and the control of the company is diluted if somebody gets a share to which rights attach, which might affect the way the company is run, and so on.
It's on that basis that Mrs. Radmacher is resisting what
Quite
Carolyn
so,
says.
but the judge is saying, well, that's not what I'm going to be doing, and therefore I don't see there's a risk.
And we embrace what Mrs. Justice Barron says in Germany to try and resist what Carolyn says. What Carolyn says, by contrast, is if you're outside of a separate property regime for more than 3 months, that's it. You've lost your shareholding. End of story. And it's that which has become the focus of the litigation.
But the whole foundation of English matrimonial property law is separation of property. That's where we start.
Right.
We just readjust it at the end by ordering transfers from one to the other. But she's always been in a separate property regime as far as English law is concerned.
Milady, your words will doubtless be transcribed and be of the most immense help.
They're sitting somewhere in Miller and Miller, McFarlane and McFarlane.
They are too, indeed, yes. Certainly there has been, of course, great debate in the European context as to whether we are formally a separate property regime.
I know, there is a problem.
You're quite.
Some people think we should own up to being a deferred community.
Well, we certainly have been reluctant to do that.
I mean, surely, Mr. Todd, the furthest you can take this point is that was another thoroughly good reason, indeed an imperative reason, why they had to have a prenuptial settlement.
It is.
But I mean, you can't, so to speak, put an interorum argument unless we reinstate whatever it is, unless we maintain the Court of Appeal's judgment. You're going to lose out even more in Germany. I mean,
that's not where I'm taking to.
All you can do is to say, well, it underlines why here it was not only a good idea, but necessary to have a P&C.
Indeed. And, my lord, we don't take it any further than saying, not only does this underline why it was necessary to have a prenuptial agreement, an effective one, but that it also goes to this other point, which is third parties are affected by these agreements. And we take it no further.
Well, that point is made even clearer by the father's payment sense and reliance on it.
Indeed, and that was the next point I was going to come to. Perhaps this is additional.
I've got down, the husband made 2 decisions of his own free will, one to enter into the PNC. Have we got to 2 yet?
No, the second one is that he chose to give up the world of being an investment banker and to embrace the easier life of firstly being a student and ultimately being a researcher.
Mr. Todd, you cannot make a submission like that in my presence.
Indeed. He found it less stressful.
My daughter is an investment banker. I have been a university teacher.
And certainly less remunerated, if I may correct myself.
Very
I'm
much
sure your
less
ladyship would have no
well-remunerated.
difficulty in agreeing it's enormously less well remunerated than
Yes,
being
but
an
I
investment
wouldn't agree
banker.
that it's less hard work.
Pleasanter, perhaps.
I take that back without any reservation at all. Certainly, as regards that decision and its consequences, it of course has a financial consequence in that he's earning a good deal less, but it was found by Mrs. Justice Barron, and this was dealt with at page 111 in Annex 1, or bound volume 2, and unfortunately this paragraph is not numbered, but it's the third paragraph down, which is entitled The Husband. Where it begins by saying...
Paragraph 138.
It's within paragraph 138.
Yes, it doesn't have a label attached.
Yes.
So the husband, it's a third of the way down.
It is. It's also, as I found, the husband was once a high earner in the city, but he embarked upon an academic life during the marriage, albeit with the intention of returning to the financial world and earning well thereafter, which of course was contrary to the case that he had run. And then it goes on to say in the last sentence, whilst he cannot be criticised for his decision, it was not jointly made in the context of the marriage, and so its effects in fairness, cannot simply be visited upon the wife in the sense that she has to fund a lavish banker's lifestyle for the remainder of the husband's life. The financial consequence of his decision must in truth be marked in the balancing exercise. And we say those two decisions, the prenuptial agreement and the giving up being an investment banker, are two decisions which he took freely, and yet he does not wish to accept the consequences of either of those decisions.
So do you say that the last sentence that you've just read should read, the financial consequence of his decision must be disregarded?
We say the financial consequence of his decision to give up investment banking
Yes.
is not something which he can rely upon in order to say that the wife should be paying him more. I'm afraid that's rather
I think
longer.
must be disregarded, isn't that what you're saying? As opposed to must be marked in the balancing exercise.
Well, I think what Mr. Justice Barron is saying there
Yes.
is the financial consequence of his decision to give up working can potentially be added into the balancing exercise by reducing his claim. So we would
Yes.
agree with that.
It reduces his claim because he
Indeed.
voluntarily adopted a less lavish lifestyle.
Right,
That's what she's saying.
indeed. And we say that's right in principle.
You're saying it should reduce his claim to nil. That's what you're saying.
We're not saying that should reduce his claim to nil, no. What we're saying is entering into the prenuptial agreement means that his claim is now one born of needing to care for the children.
What would a decision jointly made in the context of the marriage be? A discussion that he needed a bit more time with the family, and that maybe the academic life might make it easier for him to do the...
Yes.
Yes,
it would-
my lady will forgive me the babysitting or whatever.
Yes,
Yes.
yes,
Yes,
quite.
I see. That would be a decision.
That would be a decision, and that would, of course, be of relevance because the wife would have been actively encouraging or being condign in respect of him giving up a valuable work capacity.
Yes, I see.
Well, she might have said she'd like occasional dinner on high table at Hertford or whichever, was it, or Lincoln?
Hartford. But she didn't.
Right.
And that is significant in the terms of decisions that he makes, which he doesn't want to accept the consequences of.
Can we just pause for a moment to see where we've got to? As I
Certainly.
understand it, your submission is nothing in the circumstances in which the agreement was entered into that should diminish the force that should be given to it, nothing unconscionable. And therefore, the only circumstances in which it should not be given effect is manifest injustice.
Or the presence of children.
Yes, well, let's take the children out of the equation. Imagine there'd be no children at all. Would you then be saying that there is no case of manifest injustment that requires provision to be made for the husband's needs?
Yes.
So that some of the factors you've set out, paragraph 38 of your case, are really a fortiori factors. The fact he's going to have a free home and all of this, not really relevant, but it just strengthens your case.
It does. It goes to this question of, and when we use the words destitution or a hardship, we're quoting what he is saying. We don't believe that at all. But that is what he says, and we will come to reasons as to why we say that is not correct. That's the position we've got to there.
If it weren't for the children, he wouldn't be getting a penny.
Like Mrs. Crossley.
Yes.
Exactly like Mrs. Crossley. The position with the German law was set out by Herr Martens, and that's found in Annex 3, or Appendix 3, at pages 178 to 184. And although there has been some suggestion of review, this remains the only, together with Professor Kirshner, the only correct statement. And the first of these points, which we say is worthy of noting, is the definition of German notaries and the role that they play, which is found at page 179. And we emphasise that the word and the civil law system, as is well understood for a notary, is different to a notary in this jurisdiction. A notary has a quasi-judicial function, and it is his duty to act in order to provide independent advice to the parties. The rather lengthy and unchallenged description of German law goes on to say on the third paragraph of page 180 that the notar does not represent any of the parties, but is an independent, impartial consultant for the parties involved. To guarantee the independence and impartiality, the notar is appointed for a lifetime and his income is secured by giving him the right to charge official fees. And it goes on to say that the duties in respect of a notar are to be complied with strictly. He is, of course, the holder of a public office. It also goes on to say in the penultimate paragraph that when he's dealing with documents, it stipulates that the entire transcript must be read to the parties in the presence of a notar, be approved by them and signed in their own hand, as well as signed by the acting notar.
So that's why he takes the trouble to be sure that both sides understand what the agreement is saying.
Right.
But there's nothing that requires him to go further than that, into the background to the agreement and insist on disclosure of facts or whatever else.
He does. He goes on further and he advises the parties in respect of the substance, and this is Appendix 4, page 97, which is where we have the evidence of the notary in this case, Dr. Margus. And this begins at page 97, and of course it was the case that in addition to swearing this affidavit, Dr. Margus also gave evidence to Mrs. Justice Barron. And he begins by emphasising from page 97 that the notary in Germany is an independent public official qualified for appointment as judge. And that's where we get the analogy of the situation whereby if two litigants in person appear before a judge, it doesn't mean that the proceedings are thereby compromised just because there's only one person involved in speaking to both of the parties. And it goes on to say, in some parts of Germany, judges have the function of notary. In other parts, experienced lawyers can become notaries as well. So it really is very akin to a judicial office. And then he sets out the difficulty of becoming one, the waiting lists that are involved, and then at the top of page 98, the central function of the notary in Germany is the authentication of legal acts which are considered as especially important. And then he deals with the various matters, including conveyances and, of course, prenuptial and postnuptial agreements. And he then goes on to say, at the end of that paragraph, this shows that in German legal doctrine, the notary is much closer to the judge than to the lawyer. And he refers to his dealings then, first of all, with the Radmacher family. And we say this is not something which impugns his independence. He can have dealings with either parties independently. If the husband chooses not to have independent dealings with him, well, that's a matter for him. But he comes from a system, France, where notaries also exist, and one can presume that it's therefore not going to be so very alien to him. He then sets out his circumstances, which are dealt with separately in Mrs. Justice Barron's decision. And he then comes on in paragraph 4 to the parties arriving in his office. And he expresses what he describes as surprise, which in his oral evidence becomes, he describes as, he was a bit angry as well, that they'd turned up without a written translation of the draft. For me, this was quite a surprise because we clearly talked about it on several occasions. My letter of 17th of July mentioned it explicitly. So I remember that I was pretty displeased about this fact. Mrs. Katrine Radmacher told me that her future husband did not want to have written translation. Mr. Granatino confirmed this. And we're going to come back to how he says he didn't know about this because it was in German later. He goes on to say that, so they insisted to continue, notwithstanding what the notary is advising them. Both parties absolutely wanted to sign on this day because it would take an indefinite time before they came back to Germany, possibly even not before the date of their marriage in November, which was then 4 months hence. So they insisted to continue. The parties were instructed that they could demand a written translation, a sworn-in translator, and or the presence of a second notary. So what's the husband being told about the availability of independent legal advice, which he then does not take up in the next 4 months, and then prays in aid in order to renounce his bargain. He goes on to say, they renounced, declaring that the oral translation by the notary was definitely good enough for them. Again, it's them. He then goes on, so the document was read out in German, translated into English, explained and discussed in English. Reading, translation, explanation and discussion of the whole text were done in small sections. Sometimes when a direct literal translation of a single certain word was difficult, the sense of it was described with one or more sentences. In a few cases, even French was used additionally to make things quite clear. I remember the detail that, for instance, the German word gute Trennung was translated as separation of property and illustrated by the remark that this corresponds to the contractual séparation de biens quite common in Belgium and France, which Mr. Granatino confirmed with a smile. And then he says the meeting certainly took more than 2 hours, probably about 3 hours. That's in the context of Mr. Granatino saying it was 2 to 3 hours. He then deals with him. He said, as far as I remember, the parties did not raise issues apart from the text of the draft, which gave us enough to work with. At least all the legal instructions mentioned in the document were given to the parties in the meeting. And then he sets out at some length all the documents that were handed over to the parties. And then with the letters to parties written on the next possible day, I recalled to their attention some very important instructions given on the 1st of August. This letter was accompanied by more than 30 pages, copied out of the book Introduction to German Law. The paragraph, and he annotated by him. The paragraph of the contract which diverged from the legal provisions described in the book are marked on the copies. The given contrasts reflect again the above mentioned instructions. The explanations and legal instructions given to the parties were accompanied by examples, and this was our reference to him drawing diagrams as he described in his evidence and so on. The focus was to show how the provisions of the German law try to cope with typical problems arising in the case of divorce of a typical middle-class couple with children. It was pointed out that in general the provisions by the law are good and mostly just for the economically weaker partner. Well, that, of course, is part of the great debate that's taking place in England. There are, of course, cases where the weaker partner might also want a prenuptial agreement. But in any event, he goes on to say, especially for young ladies who want to raise their children themselves at home, as considered to be usual in 1957, when the fundamental principles of the present law were established. So the parties were warned that the present contract, in case of divorce, would cut off all the communicating pipes provided by the law to protect the economically weaker part of the couple. The parties absolutely agreed that they considered themselves as not belonging to the typical middle-class couple described before. Each of them declared they had an income far above the average. Each of them declared explicitly that they wanted to stay economically completely independent persons, even in the case they had children. Both parties demonstrated full understanding of the provisions of the agreement and their implications. Otherwise, I would not have signed the agreement. So that's the sworn testimony of Dr. Margus, quasi-judge in Germany.
Now, we have a finding about this by the judge, page 1991. He obviously made a good impression as a charming, perhaps rather verbose individual, but she does say that the preparation of it was very one-sided and was demonstrably not neutral.
Yes,
that's
and that
finding.
is unfair of Dr. Margus in the context of the proper law of this contract, or I use that small letters.
Page 91 in Appendix 1.
Because it's page 19 to 91, I'm so sorry,
Yes.
my lord, of either Appendix 1 or Bound Volume 2, page 90 to 91, and it's subparagraph D where it deals with Dr. Margus. And this is an absolute critical point in this case for what Mrs. Justice Barron says in the last of the paragraphs under Dr. Margus.
Yes.
Because she says this, I accept him as a witness of truth, of course, and then goes on to say, however, the preparation of the PNC was very one-sided and therefore was demonstrably not neutral. Therein we have the real error that Mrs. Justice Barron falls into, and that is an ex post hypothesi analysis of whether this was fair by looking at it in 2008 and its effect in 2008. It was not unfair or one-sided at the time it was entered into. And it wasn't unfair or one-sided at the time it was entered into, because the husband was an investment banker. Shortly, he was to be earning $470,000 per annum. He thought he would be a billionaire. He wanted to protect his assets from any claim by the wife. She, for her part, also said, well, I have wealth. There are no findings by Mrs. Justice Barron as to the extent to which he had insight into the wife's family's wealth, but we do know that the husband knew that his potential father-in-law owned a company in Germany and that it was involved in the chemistry business, although he says he didn't know a great deal more.
Were there findings as to how much the husband thought he was going to be earning or going to be worth? Business about how he's going to be a billionaire. Where are the findings, or where do the judgments deal with that?
The next paragraph's relevant, isn't it? The Cligner's affidavit.
Yes.
And the affidavits in bundle 4, 92 to 95.
Yes, yes indeed.
The background to the sentence you're attacking is surely to be found at page 90.
Yes.
Where she's saying, and I think this is consistent with what we see at page 98 in Appendix Part 4, that the document was drawn up on instructions from the wife's side.
Yes.
And
I would say,
there it is. I mean, he says that I don't think he can be. He said he was independent, but she doesn't really think he could be treated as such.
yes, and this is, we say, first of all, there's the slightly unfair, what looks on the face of it to be an unfair criticism of him saying, I'm like a German judge, I don't think I should be dealing with Mr. Moore outside of court for any sort of pre-court consultation, because that might compromise my independent status and so on. And the basis on which he says, well, maybe his independence was compromised, is he takes instruction from one side. Well, there's no suggestion that that is unusual. One imagines that a notary has to be instructed from one side at some stage, or he never gets instructed at all. It's very unlikely, we would guess, that the two parties go straight away.
Why is that unlikely? What possible evidence have you got for that?
We don't have any, that's why I say guess.
Yeah. That's a very Anglo-centric way of looking at life.
It is. It might
Maybe
well
do
be.
things in this country, perhaps.
And in those circumstances, what would happen is if there was a slight suggestion, then it would be said to this husband, have a second notary. And that's exactly what Dr. Marcus said. Dr. Marcus said, go and get a second notary. So you've got your independent legal advice.
Can I just all as I read it, Mrs. Justice Barron was saying, was that the preparation of the PNC was very one-sided and therefore was demonstrably not neutral. The preparation of the PNC.
Well,
and she goes through all of this in paragraph 38.
Yes.
In her findings.
If it is said, well, quite, I mean, that's certainly a matter that troubles me. If it is said...
But we're not hearing an appeal on the facts.
No, quite.
We're not in the slightest bit interested in an appeal on the facts. We're only interested in the facts as have been agreed between the parties.
Well, the facts, though, come up because the Court of Appeal were of the view that some of her findings were plainly wrong, or rather her approach to some of the findings were plainly wrong, and then there's an interpretation of that and the weight that's to be given there.
I mean, the Court of Appeal, Lord Justice Wilson deals with all this, paragraphs 137 all the way to paragraph 141.
Yes.
Pages 48, 49.
Yes, yes indeed.
And presumably you're content with that.
We embrace it completely, my lord. Yes, I don't pretend that I could improve on it. It's a... in fact, it was where I was coming to next in my note as to how the matter is looked at. I was just going to make one additional footnote, which is the commentary which is provided by Véronique Cheveux, which is found in Appendix 3 at page 209, where she confirms that this agreement would also be, the parties would also be held to this in France.
Page 209 in 3, is that right?
My lord, yes, it's 209 of Appendix 3.
Where is the reference, incidentally, to Dr. Majors saying you can get some legal advice yourself?
In Dr. Marcus's affidavit.
Nice, thank you. I missed it then. I'll find it.
Sorry, I'm completely lost. Why are you showing us page 209 when we've got paragraphs 78 and 79 of Mrs. Justice Barron's judgment, page 92, which I thought you can't possibly approve of?
I can't approve of it. I'm not going to show it to you, my lord. I was giving it by way of reference to say that that was before coming on to this separate matter of that's dealt with within Lord Justice Wilson's decision in the Court of Appeal. The position of the standing of the independence of Dr. Margus is then, as your Lordship rightly brings us to, is dealt with at page 48 of Appendix 1 or Bound Volume 2. And this is, of course, in the context of what I had meant to mention by way of essentially footnote, the decision of, or the view of Véronique Chauveau, where she confirms that this agreement would have been enforceable in France as well as in Germany. And Lord Justice Wilson deals with this question of lack of independent legal advice in this way.
Which paragraph are you looking
it's
at?
page 137, paragraph 137, page 48.
Yes, right. Yes.
Where he starts from a proposition with which, again, we fully embrace what he says. In most cases, it is necessary, and in every case, it is desirable that the party against whose claim a prenuptial contract is raised should have received independent legal advice prior to entry into it. We agree with that. Why so, he says? Because proof of receipt of independent legal advice is often the only and always the simplest way of demonstrating that that party entered into it knowingly. And we say that is also right. All the safeguards which are suggested are not just boxes to be ticked in their own right. They are exactly what they say. They are to safeguard against something such as a party not genuinely entering into an agreement, them not understanding an agreement or something of that sort. And he goes on to say, in the present case, however, the husband did not deny that he had a clear appreciation of the possible consequences of the contract. And indeed, that is what Mrs. Justice Barron appears to have found. On the contrary, the judge found that it was abundantly clear to him that its effect was that in the event of divorce, he was to be self-sufficient. Nor did the husband suggest that had he taken independent legal advice and been advised not to enter into the contract, he would have entered into it, or would not have entered into it, thank you, or would even have sought to secure variation of its terms in his favour. And that, of course, is the difficult question for him, which he is very reluctant to answer. Had he got that legal advice, how would he have dealt with the matter differently? Because he can't answer that and still be able to pursue his case, which enables him to resolve from his agreement. Because...
Is this coming down perhaps to burden of proof? If you want to get out of the agreement, you've got to show that it was concluded in circumstances which were unfair because had you known the full facts or had you had independent legal advice, you would have acted differently.
Right, yes.
You say that it's for the husband to demonstrate that, and it's not enough just to stand back and say, well, there's no evidence.
Quite. It's not like those regimes which are not analogous to us, those regimes like Australia, for example, where they say this contract will be binding on the parties, and therefore, because we are legislating for everybody, we have certain boxes that need to be ticked, because they will tend to point towards showing that the people have freely entered into those agreements and they've entered into them on an informed basis. We don't have that system, and rightly, perhaps, because this enables the courts to bring specific remedies to specific cases. And the significant question which he was unable to answer is what impact would it have had if he had had legal advice, if he'd have taken up the opportunity, either getting another notary or alternatively on coming back to an Anglo-Saxon country as described, then getting independent advice here. And it is the case that he doesn't ever deal with that, and yet if he wants to avoid his bargain, he needs to articulate that. Doesn't do so, no finding in his favour in respect to that. And Lord Justice Wilson doesn't refer to this point, but it has arisen, which is, well, what would happen if he had come to this country and he asked for an opinion from an English lawyer properly informed as to what the law is, and as to what the meaning and effect of these agreements would be. And my learned friend puts great emphasis on the case of F&F, which was, of course, the case which questioned their effectiveness. That's not the advice he would have got in 1998 from a competent lawyer. A competent lawyer in 1998 would have been looking at one of the more recent cases to have been decided, which is found in the authorities' volume supplemental 2, which is the decision of S&S, which was decided later than F&F and expressly deals with S&S. And it's tab 169, yes, my lord. Thank you. And this was a case involving a Swedish and a wife of Swedish origin who'd married an Austrian-born husband in 1987. They'd owned properties in various countries, and they had negotiated and executed a prenuptial agreement in the state of New York. There was then a dispute between two jurisdictions because in 1996 the wife had started divorce proceedings in England, and a week later the husband filed proceedings for divorce in New York and applied for a stay in the English proceedings under paragraph 9 of Schedule 1 of the Domicile and Matrimonial Proceedings Act 1973 for the matter to be stayed on, in effect, forum convenience. And in considering the circumstances of this case, Mr. Justice Wilson, as he then was, referred to F&F at page 1203, just below letter D. And he says this, and this would form the basis of any properly advising lawyer at this time. I am aware of a growing belief that in the dispatch of a claim for ancillary relief in this jurisdiction, no significant weight will be afforded to a prenuptial agreement, whatever the circumstances. I would like to sound a cautionary note in that respect. No one could have more profound respect than I have for the observations of Lord Justice Thorpe. In F&F, ancillary relief substantial assets, he said, in this jurisdiction, prenuptial agreements must be of very limited significance. The rights and responsibilities of those whose financial affairs are regulated by statute cannot be much influenced by contractual terms which were devised for the control and limitation of standards that are intended to be of universal application throughout our society. And your lordships will recall that that is the phrase which he has since disavowed himself of in this case, or certainly put some distance between him and that case, a recognition perhaps of the evolution of approach to these cases in the last 15 years. He goes on to say, there is a danger that these wide words might be taken out of context. There is no doubt that where the English court proceeds to determine application for ancillary relief, Section 25 of the Matrimonial Causes Act precludes any choice of foreign law, however vividly the circumstances of the case might protest its relevance. So the application is of English law, and under Section 25(1), regard must be had to all the circumstances of the case. In F&F itself, the result of a strict application of the effect of the prenuptial agreements would have been, as the judge said, ridiculous. In those circumstances, they inevitably constituted circumstances of negligible significance. But there will come a case where I to refuse a stay, might this be it, and of course it wasn't going to be it because he didn't refuse the stay, where the circumstances surrounding the prenuptial agreement and the provision therein contained might, when viewed in the context of the other circumstances of the case, prove influential or even crucial. Where other jurisdictions, both in the United States and in the European community, have been persuaded that there are cases where justice can only be served by confining parties to their rights under prenuptial agreements, we should be cautious about too categorically asserting the contrary. I can find nothing in Section 25 to compel a conclusion so much at odds with personal freedoms to make arrangements for ourselves that escape from solemn bargains carefully struck by informed adults is readily available here. It all depends. The matter must be left open, and on the footing that, were she to be enabled to claim ancillary relief in England, the wife might secure an award of substantial further provision. And then he goes on saying, what follows my duty is to appraise the relevance of the prenuptial agreement to the termination of this particular issue.
I must say I find that this area of the case particularly elusive. The husband is about to sign an agreement. He hasn't got independent advice about the agreement. The only factor that anyone's pointed to as being relevant in relation to that advice is the extent to which the agreement would or would not be held to be binding in this jurisdiction. How does that affect his willingness to sign it? Well, if he's told it will be binding, does that make him less or more willing to sign it? If he's been told it won't be binding, if he's been told it may not be binding, I mean, how is this really relevant at all?
Quite, absolutely. Your Lordship's got the point. How is it relevant at all to someone trying to escape their
well, why are we looking at what he would have been told?
Well, this came up
it wouldn't make any difference whether he was told F and F or S and S.
Well, the case that was put forward, and it's the case that I'm answering, but if it's not going to assist, I'm not going to trouble you any further with it, was that he would be advised this would be of no effect. That's not the advice he would have got in 1998. This decision...
Well, whichever advice he would have got, do you say it would have made any difference?
To this particular husband, it would have made no difference.
Well, then why are you looking at it?
Because it's raised by him as saying it would have been material, whereas we say either way it would not have been material. But I take your Lordship's point and I will move on.
Well, could I, if you don't mind, if I could ask before we leave S and S, that quotation, Lord Justice Thorpe in F and F, which is set out in the middle of page 1203, has been read to us many times. I find the second sentence very, very difficult to understand. What noun does the word which refer to?
Forgive me, my Lord. Well,
yes,
just
so
reread
take your time to read it, because I find it more and more puzzling the more often I read it.
Well, the short answer is I don't know, my Lord.
Because the notion that two parties negotiate contractual terms for the control and limitation of standards intended to be of universal application throughout our society seems to me an incomprehensible thing to say, with huge respect to Lord Justice Thorpe.
With respect, I entirely follow my Lord's reasoning. The devise for the control and limitation of standards that are intended to be of universal application throughout our society is obviously really referring to the regulation by statute, isn't it?
And the which is the contractual terms.
Yes.
The contractual terms have been cobbled together by the parties in order to control and limit the statute.
Yes, yes. Thank you. I have to say I hadn't focused on that second sentence, but yes, that must be the interpretation.
Statutory provisions might have been a better way of putting it. You need a plural.
Yes. It may well be that, certainly in light of what Lord Justice Thorpe has subsequently said in this particular case, that F and F will not be of such central significance in the future. The reasoning, though, of Lord Justice Wilson in respect of this question of whether there was a lack of independent legal advice goes on to the next, in the next paragraph, to what we say is an equally significant matter, which is whether or not he had the opportunity of independent legal advice. And this is a point of departure between him and Mrs. Justice Barron, because he says that had the husband wished to take independent legal advice, particularly perhaps on the effect of the contract in England, in the anticipated event that his married life with the wife was to be spent here, he had more than sufficient opportunity in which to do so. It's hard to dispute. He had more than 4 months since he first knew about this prenuptial agreement, 4 months after the prenuptial agreement, in which to take that advice. And as Lord Justice Wilson continues, he was aged 27, and at that stage an investment banker earning £120,000 per annum. On or about 24th July, the wife had shown him the draft and made its basic terms clear to him. and he had responded that he did not need a translation of it. The reality is, he knew full well about the possibility of legal advice, and we suspect that if he were to answer that question, what difference would it have made? The answer is none, and that's why he didn't bother going and taking any. Because he wanted to marry this lady, and he knew there would be no marriage, save for the entering in of the prenuptial agreement.
And that's a point you've made a number of times, and I'm just wondering where it leads us. If you're madly in love with somebody who says, unless you sign up to this agreement, I won't marry you, is that something you can prenade afterwards, saying, well, I shouldn't really be held to the agreement, having regard to the emotional state I was in when I signed it? I actually thought it was very unfair, the agreement, but if I had to sign it to marry her, well, I was prepared to do so.
Well, that is a circumstance which does apply right the way across the world of contract as well as in these sorts of agreements. And it's going to ultimately be fact-specific. You will get some people whose will is so overborne, people who are so flighty and so lacking in independence of thought that they simply are not able to form the proper intent. But that's not this case. So the answer is, yes, there can be circumstances where they are so overwhelmed by that, but this is not one of those cases.
Well, you can be madly in love without being flighty, and it seems to me your case that the husband was madly in love.
If it's the case that somebody desires something a great deal, whatever it may be, whether it's a marriage or a car or a house or anything else, it's not then open to them to say, well, I wanted it so much, I was prepared to pay the price, and now I'm not so keen, I don't want to pay the price anymore. But that's the effect and the logic of that argument. It's always extraordinarily...
Well, that's what landlords used to say about tenants who were prepared to pay exorbitant rents because they so much needed a roof over their head.
Well, again, it becomes a question of circumstance. And if it's the case that he wants to marry and also he wants to get the protection for any future earnings that he might have, as the wife contended, then that's not a very good reason in this particular case for him to be released from the fairness of his bargain. And it's not as if he has articulated a case of his free will being overborne on that basis. The way that he says that this agreement should be impugned is, in effect, the box of him actually taking independent legal advice was not ticked. He, of course, knew that he had to take or that he had the opportunity of taking legal advice if he wanted to. This is not one of those cases where the prenuptial agreement was signed on the night of the wedding so that there wasn't any time for there to be that sort of consideration. As Lord Justice Wilson goes on to say at the following page, in what is the third paragraph, about 8 lines down, that the parties were under no significant pressure to execute the contract on that date, and had the husband requested postponement in order to take legal advice, Dr. Margus would have been the first to stress to the wife that that request was reasonable. But there's two sides to this as well, as there are in respect of all these agreements. It's not just the fairness to the husband, it's the fairness to the wife too. She says, I want you to marry me, not for my money. And that's very important to me emotionally. And he says, well, okay, I don't want to marry you for your money. I will sign that prenuptial agreement. These emotive issues are only critical for undermining an agreement, we would say, in circumstances where someone's true free will has, in effect, been suborned. And that's not the case here. From the part I was just reading, Lord Justice Wilson continues that at the hearing we asked Mr. Mostyn to explain why, as suggested by the judge, the wife's presentation to the husband that the impetus for entry into the contract emanated from her father had led the husband to take it far less seriously than he should have taken it, and had thus lulled him into a false sense of security. Mr. Mostyn was unable to explain and thus to defend the judge's reasoning in that regard. That is, of course, correct. And this is all part of a husband who is deploying every skill he has to avoid his bargain. And at this moment, I'm going to come back to independent legal advice. It is worthy of recollection that when first faced with this prenuptial agreement, the husband's case was found in his Form E, which is in Appendix 3 at page 102. And again, this was the subject of findings, but it is worthy of revisiting.
What are we looking at here?
This is his Form E, which is his
Form E.
sworn statement in the financial proceedings.
Yes.
And it's page 102 of Appendix 3, and this is where he first introduces the question of the prenuptial agreement, or where it's first dealt with by him. And he says in the very last box, in the second paragraph of the last box, the petitioner and I entered into a prenuptial agreement in Germany before we married. At that time, I received no legal advice. Well, no legal advice is questionable in itself. But he goes on to say, the document is in German, and as I do not speak German, I have no idea what it says. I only signed the agreement because it was required by the petitioner's family before we could marry. So what he's saying, he says, no legal advice. Well, that's not true. He doesn't like the independence of the legal advice, but he certainly does have legal advice. It's provided by the notary, as is common in Germany and France. And the comment about German is worthy of considering in terms of the tenses that he uses. I have no idea what it says. That's present tense. So as of the date of swearing his Form E, he's saying he doesn't know what this says. That's the 29th of January of 2007.
Where does the judge deal with that?
Mrs. Justice Barron describes this as unfortunate, and she deals with it. She deals with it in the bound volume 2, which is also appendix 1, at pages 82 to 83 in paragraph 44. And what she says is less than ringing endorsement of the husband. It's for completeness, the wife drew attention to the inconsistency between the husband's Form E, where he says documents German, as I do not speak German, I have no idea what it says, and his maintenance pending suit affidavit, where he says the notary explained in broken English. Just pausing there, the notary was never challenged on his English when he was in the witness box as to the quality of his English, presumably because it was obvious to all that his English was certainly sufficient, if not idiomatic. What the various clauses said, but he did not give a verbatim translation of the agreement. Husband explained that by the first statement, he meant that he did not have a copy of the agreement when he compiled the Form E, and therefore could not recall the precise terms. That may be correct, but it is unfortunate phraseology. He also maintained that Dr. Margus did not give him a lucid translation. I feel sure that Dr. Margus did his best, and so on. But that finding by the judge has to sit also with her finding at paragraph 139, where when she deals with conclusion and award, and it's in the third from last sentence, where she says, nevertheless, he understood the underlying premise that he was not entitled to anything if the parties divorced. In essence, he accepted that he was expected to be self-sufficient. As a man of the world, that was abundantly clear. His decision to enter into the agreement must therefore affect the award. And so, when one is looking at this husband, it is in the context of a husband who has presented a case which is unfortunate in respect of the German. He's not believed in respect of when he first saw the prenuptial agreement, and he's described as giving false evidence in respect of his account to become a student. That they are the circumstances in which this man's evidence is being reviewed by Lord Justice Wilson, and in the context of how it is that any weight should be attached to him saying this would have been material in his agreement or not. And going back to the judgment of Lord Justice Wilson, Lord Justice Wilson makes some telling points from the facts that are discovered. He goes on to say, First of all, about the parties are under no significant pressure to execute the contract because they were still 4 months or so away from the agreement. And then in paragraph 139, he makes, again, the valid criticism of the husband's case. Indeed, at the office of Dr. Margis on the 1st of August, the husband had a further perfect opportunity to postpone execution of the contract until he'd been furnished with a translation and had taken independent legal advice. Rather, we should say what he terms independent legal advice, not what Germany does. For, angry at learning that the husband had not been so furnished, Dr. Margis himself indicated that he was minded to postpone execution, but was persuaded, no doubt, by both parties to proceed with it. Thus, the husband was directly exposed to the emphasis placed by Dr. Margis upon his right to have further time in which to digest the effect of the contract. But the husband, in effect, responded that he neither needed it nor wanted it. So it's a question of opportunity of legal advice being available to the husband in any event. One of the matters which, taking this in order, which again is the subject of the Court of Appeal's assessment, is the absence, of course, of disclosure of the wife's means. And Lord Justice Wilson, dealing with him first of all, emphasises, he begins at paragraph 141 at page 50, prior to the execution of the contract, the wife did not disclose the approximate value of her assets to the husband, nor for that matter did the husband disclose the level of his income to her. Mr. Mostyn strongly relies on the judge's findings that the wife requested Dr. Margis to exclude from the contract clause relating to the value of their assets, and that she wanted to keep her asset basis secret from the husband, and a position he repeated yesterday, as indeed he did emphasised in the Court of Appeal. And this qualification, again, best said by Lord Justice Wilson than me. But in my view, more is needed before this feature vitiates the contract. To be specific, there has to be a causative element. What is lacking is any finding by the judge that had there been accurate mutual disclosure, he would not have, or might well not have, or perhaps even might not have entered into the contract. He knew that the wife already had substantial wealth, and he showed no interest in ascertaining its approximate extent. Finance was, at that time, the subject of his career. He does not contend that he felt unable to ask for details of the wife's wealth, and we emphasise that. This is not a case, he says, of her husband saying, well, she was very secretive, I knew if I asked her it would cause some sort of rupture. There's no sort of case like that run at all. He doesn't proceed with that at all. He felt unable to ask for details of the wife before agreeing not to claim against him eventual divorce. And then this is, again, a telling point. On the 1st of August 1998, Dr. Margis, speaking in English, clearly and in detail explained to both parties the terms of the agreement, including the term that despite advice from Dr. Margis himself, they waived the possibility of appending to the contract a schedule of their assets. It was entirely open to the husband, even then, to say that he considered the advice of Dr. Margis to be wise and that mutual disclosure should take place. And the wife's likely displeasure cannot, in my view, sensibly be regarded as foreclosing that opinion. And one option. I'm so sorry, option. And that clause is annexed to the is rather recited in the agreement, and that's at page 122 in the same bundle. This is after a page of having separate property described, what it's and being informed about its meaning and so on. It then concludes with this paragraph. Despite advice from the notary, we waive the possibility of having a schedule of our respective current assets appended to this deed. And a significant point of difference between the appellant in this case and Mrs. Radmacher is the question of opportunity. He is now taking the opportunity of trying to resile from the agreement on the basis of matters that he was aware of at the time and chose not to look at. He was aware of the opportunity and potential of independent legal advice, second notary advice in England, had time to do it, 4 months and so on, had the wherewithal to do it, earning good money as an investment banker. Next one, absence of disclosure. He expressly recites that he's waiving his rights in respect to that. And again, it's not in the context of him ever saying, or it being accepted that it is the case, that he is unable to ask her because it would have some sort of deleterious effect as to what she would have.
Do we have the original of this document somewhere? Do we have the original of the prenuptial agreement?
As opposed to a photocopy?
No,
the German, I'm so sorry.
German, this is translation.
We took it out of the bundle, but we certainly can locate. We'll locate a copy, my lord. It's not in the bundles, though, in the German, as there was the notarized. We'll deal with that. And your lordship is absolutely right to go back to the German. One of the points of focus originally was the translation of the word erect, and whether or not that could be potentially interpreted as meaning that, as the parties both said in their oral evidence, that they'd intended there to be a jurisdiction clause as well as a proper law clause, whether or not that had achieved that. And Dr. Margis was absolutely clear about that. It was not intended to say that, and it was at that stage that we abandoned any argument to say that this was therefore something which could take advantage of the principles of prorogation. So. Is it? I'm so sorry, Lord, because I've skated over it. It's in Appendix 3, page 62 and 63. 62 onwards.
It's all one document, and the clause you referred to, the document must, if that clause was the result of a specific agreement, the document must have been effectively reproduced, amended electronically, and then reproduced.
Yes.
And there must have been therefore a gap in time, I suppose, sometime during the meeting while that was happening at the end.
Yes. Yes. It's at the bottom of page 66 is the German clause. My lords, the next matter that was prayed in aid of being a potential circumstance which would mean that little or no weight should be attached to this agreement was the absence of negotiations, and we deal with that very simply, which is negotiations are not a fundamental requirement of any agreement or contract. And it must be plainly wrong that that's taken into account. We don't know at any stage the extent to which Mrs. Justice Barron accorded weight in her decision to these matters. So we don't know the extent to which the absence of negotiations featured in her discounting down this agreement. It may well be it's something that played heavily upon her mind. It may well be that it wasn't very significant at all. We simply don't know. And as we don't know whether or not any weight was applied, and we'll come on to say that we don't think any weight at all was applied, then that is a matter which again entitles the Court of Appeal to have real concern about the judgment from the court below. The next matter which was prayed in aid was the birth of the girls as being a reason to depart from the agreement. We say this agreement, and it has always been the case of Mrs. Radmacher, that this agreement is something which did not purport to deal with provision in respect of children. And it is well established that when we come to look at provision for children, that also includes an element of carer's allowance. The children spend something like 30% of the year with their father. and he is generously provided for by the order of the Court of Appeal in respect of the time that he spends with them, both in terms of maintaining them and also his carer's allowance. The allocation that he has for looking after these children for that 30% of the year is £146,000 net of any calls upon that sum to look after them. In addition to that £146,000, he's also provided not just with a £2.5 million house for their minority, but he's also provided with a property in the south of France near Monaco where the mother lives. One of the curious features of this case is that the husband is so keen to acquire a property, potentially costing upwards of €10 million, for his rehousing in the south of France, they being the property particulars that he's shown as illustrations. One imagines that in the light of Lord Justice Wilson's words, he's going to temper that. But he wants a valuable property when 20 minutes away live his parents in a property in Antibes who aren't there for 183 days of the year, or at least 183 days of the year.
Yes, well, now we're getting into facts. Can we just go back to principle for a moment?
Indeed.
Circumstances in which one would depart from the prenup. Two girls are born, and he's going to be having to look after them for part of the time. So it's reasonable, isn't it?
Yes.
That this is something that hasn't been taken into account, that he should be given the resources he needs to look after them rather than have to find them for himself.
Yes, my lord, it is. It is
Not
reasonable.
just because of their own welfare, but from his position.
It is indeed reasonable that there should be provision made because of these children. And indeed, in the decision of MacLeod, that was the separate heading. In fact, there were three headings. I referred to manifest injustice. I just settled on the one because I thought the other two could be encapsulated within it. But I do the board a disservice by doing that because the three are independent, in fact. The more one thinks about it, apart from manifest injustice, the provision for child must survive. It probably is deserving of a small qualification, which is it must be possible, and one thinks of variation of Trust Act cases where provision is made for children, or one thinks of the situation in the Hill and Morgan case that's referred to, where capital provision is made for the welfare of a child, for in effect, or indeed another case where school fees were capitalised, it must be possible to make capital provision for children for the future. Indeed, one imagines that many mothers would welcome that, as it's free of the insecurity of the maintenance creditor not paying at some stage in the future, or maintenance debtor not paying at some stage in the future, or dying, or his financial circumstances changing and going bankrupt, or whatever. So potentially, it must be the case that a prenuptial agreement, let's say a prenuptial agreement that settles £20 million into a trust fund for children, could make provision for children, but we accept that on the facts of this case, it did not, it was outside the scope, and it's something that remained live for provision to be made. We thought the provision was too high, we lost that point, we've not appealed it, and that remains the position here.
Can you summarise what actually he gets in respect to the children, conveniently at page 3 of your printed case, under paragraph B?
My lord, yes.
He gets the use of a £2.5 million property rent-free for 15 years, i.e. till the youngest child is 22. Will have been then rental. House rent-free for 20 years post-separation. The holiday home, again till the youngest child is 22. Personal income of £76,000 per annum, carer's allowance, capitalised Duxbridge £912,000. Child maintenance of £70,000 net per annum, even though he's not the primary carer.
And relieved, of course, of the burden, notwithstanding he has a net income of £146,000 plus his own net income, he doesn't have to make any contribution to the mother either, which is a real benefit for someone who's not the primary carer of a child. He gets the car. His debts, of course, were paid off.
Isn't there a problem about debts? One of the points made against you is that there are quite a lot of other debts. This is made in bound volume 2, page 301. Quite a lot of other debts which actually eat into the capitalised sum of 912,412, which is the item 3, which is supposed to be a carer's allowance, but in fact it's going to be eaten up, all save £227,534 by various debts not covered by the debt payment of 700,000. Now, Lord Justice Wilson discusses the rationale of the debt payment, and one can see that it might have been argued about, but the reality is that the concern should be for the children, and is it right to leave, actually, any outstanding debt which will effectively remove most of his carer's allowance, even if it's, in a sense, perhaps his fault in pursuing unsuccessful legal proceedings?
Lord, we address this, and it's in Appendix 2 at page 267.
What's the date of this document?
This is the, the 9th of July 2009. So it's after the decision of the Court of Appeal.
Post-Court of Appeal.
It's post-Court of Appeal, Lord, yes. And what we say, this has been taken and used to describe a position adopted by the wife which is incorrect. We don't accept this is a man who is going to face destitution or anything like it, and it needs qualification in the context of what the whole document actually says. But in paragraph 3, we say this: the wife remains keen to end this litigation as soon as possible. Further, she has no desire to see the father of her children destitute. That's him. That's him saying, I'm going to be destitute if this order is made. So we're saying, well, we don't want you to be destitute. And so we therefore propose to you that if you're not going to incur the further costs and pain of this case continuing on to what was then the House of Lords, then we agree to, first of all, settlement of the houses in London and Monaco on the same terms as the Court of Appeal. But then in subparagraph B, a variation, first of all, a payment of whatever lump sum the court determined, which was the £912,000 figure. That's subparagraph B. She would not pursue her costs of appeal. That's one of the debts that my learned friend says is going to cause such great hardship to his client.
And then she's offered the remaining costs.
Right, absolutely. That's his indebtedness at that time of July of 2009. He's chosen to throw the dice and not accept this. In fact, more than that, we've never even had the courtesy of a reply to this letter or this response. All we've had is a note sent to the Court of Appeal saying that the Court of Appeal should not be involved in triangular negotiations. Not even so much the courtesy of a rejection of this proposal. And that does rather suggest, as we maintain, that this man, who is backed by multi-millionaire parents, is not going to be destitute. He is able to turn down this proposal that would have met his entire indebtedness. When we agree to pay the £484,878, that includes huge costs in respect to the Children Act proceedings, which we simply don't understand because, and we say we don't understand, because they involve over £100,000 worth of costs, which look as if they've been spent on English lawyers in respect of proceedings in Germany, which he was unsuccessful in respect of for a mirror order, and English lawyers in respect of proceedings in Monaco. It's an unhappy feature of this case that questions of contact remain an issue. Indeed, only yesterday, I think, the issue raised itself again. There's been a further application this time, I think, this application by the wife within ongoing proceedings for there to be definition of the contact. Girls having said they want to stop on a Sunday rather than go to Monday. So that's something that still goes on. But in respect of his costs at this moment in time, he would have been debt-free. The rest of the order was again embracing that he'd have £70,000 a year. So he would have left on this basis, had he even responded to it, with the use of a £2.5 million house, during which time whatever income he has, he is able to use towards his own resources, untroubled by having to pay a mortgage, unlike most people in their 30s, and untroubled in respect of the holiday property as well. And also, of course, he's getting 146,000 a year by way of the net income. So, to answer your Lordship's question of how do we deal with the indebtedness problem, we tried to. We said, we will make provision on this basis, we will agree to what is in effect a Leary order of costs against us, notwithstanding that we were successful in the Court of Appeal. We would allow the cost order below to stand, we would allow to pay all these other costs. And my learned friend has referred to various other applications you've got costs in respect of. Well, if the wife was condemned in costs in those, where she has been condemned, I think she has paid those costs. Those other matters remain for the local determination. But this was how we tried to leave him, and it was dealt with by us not even getting a reply. And that goes to how destitute he really thinks. My Lord, I'm conscious
Yes, we'll
of time.
adjourn until 2 o'clock.